Okay, if I get everyone's attention, we're gonna call to order the Rules Enactments and Intergovernmental Relations Committee meeting. Y'all, please rise for the pledge. One of the sounds. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, I'd like to ask everyone to silence their cell phones. And, Doreen, can we get roll call, please?
Absolutely. Amo, Cheney.
Here.
Sergio.
Here.
Hines.
Here.
Padu.
Here.
Sierra. Stiganga. Rich.
Here.
6 present, 2 absent.
Okay, thank you. First up, we have Richard Golden, County Attorney, for an overview of the law department. Mr. Golden, the floor is yours.
Thank you very much, Mr. Chairman. As you know, I gave you a handbook that we created for purposes of orienting new attorneys. And I'll get to that in a minute. But as our oversight committee, I wanted to tell you, give you a status on the various 5 litigations that we have pending with respect to the homeless being sent up by New York City. We just received a few hours ago a decision in one of those, the one where the city of New York said, for judicial economy, we think that all of the upstate counties and their lawsuits ought to be combined in one lawsuit in New York City for a New York City judge. We obviously oppose that, so have all the other counties. The judge issued a decision, as I said a few hours ago, with respect to one of those counties, Onondaga. And it was a very good decision for us. I would be surprised if we didn't get a similar result. So the judge was very plain and direct, and when the city was arguing that it's to consolidate all these down there, not to do that would be a waste of judicial resources. And the judge said, what's really a waste of judicial resources that you're trying to bring all these other actions that are elsewhere down to New York City and start a new action. And said also, with respect to the city's argument that, well, the main argument that you can make is to try to consolidate elsewhere. They said, well, it's all arising out of facts that started in New York City with the migrants being sent to New York City. And the judge took issue with that as well and said, no. He said, what's being challenged in these lawsuits is not something that started out in New York City. It's the fact that you sent people upstate, and it's the upstate county executives who issued various orders, and you're challenging those orders. Therefore, the relevant facts are the challenge to those orders, which is all the upstate counties. Doesn't apply to us yet, but it's a very good sign that we may be able to get out from that lawsuit. That was the one that concerned me the most, because if in fact all of those were, including ours, were now before the New York City judge, that they might try to unwind the preliminary injunction we have against the city. And then at any time, the city might then be able to send as many people as they want. So cautiously optimistic with respect to that. As you know, we've used outside, we started the action, Carol and others in the office started our action against the city. And we held that in-house for a while until it was no longer just our 2 actions, one against the hotels, one against the city. When we got sued by the New York Civil Liberties Union down in federal court, when we got sued by the hotels in federal court, when we got sued by the city, state Supreme Court, it was just too much for our office to handle the people that we have, especially being down 4 attorneys. So we went to outside counsel. And they're handling all of those. And it's very difficult in the sense that all these are going on simultaneously. So when one judge will say, I want all these, here's a motion, and I want everybody's responses by tomorrow, the day after. And then another judge, another one says, I want something by next Wednesday. Another one says, I want something by next Monday. And then you're also going down to court physically sometimes, other times virtually. So there's a lot of resources that needed. So we went to outside counsel, very good firm, Blakely Plattwood, Westchester, represents a lot of municipalities. It's not one of the huge firms where they have several hundred attorneys, but I think they have 50 or so attorneys somewhere around there. It's a good medium-sized firm. And we just got their first bills and they've been very reasonable with us. So for the month of June, for all of the cases combined, they have charged us a little over $38,000, which I think is very fair, given all they've done, all the papers that they've done, research, writing, appearances, etc. So I just wanted you to, if you're my oversight committee, to update you on that current development.
I just want to know what jurisdiction rendered that decision.
The one in New York City. The
Oh,
one
okay.
where
So
the
that's the
city-
New York City decision.
Yes, that's the one case that I'm most fearful of.
Yeah.
Because they could have unwound what we have here that we got in our Orange County case. So that was the one that I was concerned because we didn't have much control over it. I'm not as concerned with respect to some of the federal actions, but that one was very concerning because it had the ability to immediately disrupt the status quo that we have now, where we have 186 or less in these hotels, and it's not going to blossom up to thousands.
Any other questions?
Okay, so I had put together this handbook to orient new attorneys to sort of, because attorneys come in, county government is very different, and even within county government, the different forms of county governance, et cetera, allowed in the state. So I did this to orient them as to the history and organization of our county government, functions of the two branches, balance of power, also describing many of the, all of the departments and offices, elected offices, as well as many of the other boards and agencies that we represent, to give them an idea as to the scope of what their role is with respect to the entirety of Orange County, including litigation roles, concerning representing the entire county, like we are in these various cases, as both plaintiff and defendant. And also we have litigation. I'm sure this committee knows, we're the ones that are responsible for prosecuting all juvenile delinquents in Orange County. So we have that role. We have the role of prosecuting abuse and neglect petitions and family court on behalf of the Department of Social Services. We have special needs trusts. We have all sorts of other obligations that we have litigation around. So the purpose of this was to orient them, and it's written pretty much from a lawyer's point of view to a lawyer. So I apologize a little bit for the stilted language at times that it has, especially when lawyers speak to other lawyers. It's more shop talk than anything else. So, so that's what I did. But then I had the idea that it might be helpful as the oversight committee to understand how we understand our role in county government, which is why I sent it here.
On page 7, the second paragraph starts it as important to understand. And so it also discusses the different departments, nor may they waive attorney-client privileges. I guess I'm trying to understand what that all.
Sure, and that's sort of getting down into the weeds of lawyerese. So under the charter, we represent the entirety of the executive branch. And so when you represent a sort of a corporate entity like that, this is a municipal corporate entity, but even when you represent private corporate entities, there's always a question of who is the client and who has the ability to waive or invoke the attorney-client privilege. So in this case, in our government, the way it's set up is that there is an attorney-client privilege with respect to all members of the executive branch in our department. And we would also have an attorney-client with respect to the legislature on litigation against the county in which we discuss with the legislature about that litigation. I think it's all part of the same county that's being sued. But it's always important for a lawyer to understand and for the client to understand as to who can waive that privilege. For instance, in a private corporation, even though a low-level administrative clerk in a corporation is part of the client, that low-level administrative clerk has no authority to waive attorney-client privileges on behalf of the entire corporation. In a similar fashion, the only one who can really waive the attorney-client privilege in the executive branch is the county executive. That's really who animates our client and our direction for the law department as to all of them. So if we had discussions with the health department that were attorney-client conferences, the health department doesn't have to say, all right, well, I don't really care that you want this secret. I want to tell people, and therefore I have the right to tell people. They don't. Only the county executive can waive that privilege.
How does that then relate to the legislature and departments coming before the legislature committees relative to that?
Well, they-
My privilege. And I know you stated elsewhere that, you know, you're when they're here, you're here to kind of represent them, keep
Right.
them from saying.
So they would not have the ability, speaking with you, to waive any confidences that they have that they glean from our department. And so, or our advice to them. Now, as a matter of course, there are all sorts of advice that we give. And some of that is not sensitive in nature. So we would tell them, yes, you could go ahead and ask for this type of thing. Yes, you're allowed under the charter to ask for appropriation. So we would not stop them from saying, yes, we're allowed to do this, even though it's technically attorney-client. Right? So, but we want to make it clear with the departments especially, that if for some reason, and there's very few reasons why there would be confidences and secrets as against the legislature versus as against the rest of the world, right? So as against the rest of the world, there's many conflicts and secrets. But there would be very few, I can't even think of one offhand, but certainly there could be the possibility of we would have internal information that we wouldn't be free to share with you. And it's not because we wouldn't trust you, but if it's considered acting outside of the privilege that is the executive branch on us, other than when the county gets sued for something, we speak to you in confidence and we can talk to you with attorney-client privilege. And I have with this legislature concerning some caucuses and some things outside caucuses, in which we've talked about litigation against the county. But the trouble with, if we were to take an attorney-client privilege, and I would discuss it with you, and you were not considered to be part of the attorney-client relationship, and under the charter, we're not your attorneys, that's each of attorney. If we shared it with somebody outside of the attorney-client relationship, then it's waived as to everybody else forever, right? So same thing in private practice. If you're telling your advice to the corporation, but then you also say to somebody else outside of that, oh, I told them this. Now the attorney is now waived it practically, and that attorney advice is no longer privileged. So that's really the essence of it. I don't think that you have to be worried that there is a whole body of confidences and secrets we're holding back from the legislature. Practical matter.
You know, when we get into something sensitive, it's executive session.
Right, and we could, on certain circuits, share it with you. If we were ever in a situation where I had something that I couldn't share with you, I would try to figure out a way that we could, or I would be upfront with you and say, I can't tell you this kind of thing because I'm fearful if I do, it will be waived and other people will hear it, and then that would jeopardize the county as a whole. I do not know presently of any information that I have that's a confidential secret protected by the attorney-client privilege from the executive branch that you were not aware of.
Page 16. The first full paragraph deals with this, who has the right to sell county property.
Right.
And I know we've had discussions about this in the past, but I guess my reading of it is that the county executive branch could do that without our approval.
Well, I think that if they did it, it would be challenged. And the challenge would be whether or not, despite what it says specifically in the charter, that there's been a matter of practice of interpretation of that charter by both branches, that it's a shared responsibility. This came up when I became county attorney in 1994, and it was very clear that there was a longstanding practice that this was a dual responsibility that's shared, that the county, and ever since that time, without exception to my knowledge, and certainly while I've been county attorney, both in first stage and second stage, that we have not done any conveyances of real property, including easements. Licenses are a different matter because they're more contract than transfer of real property. Licenses, easements, conveyances in fee and otherwise, that has always been done jointly with the legislature. Those transfers haven't occurred without the legislature, nor will they be under my jurisdiction.
But according to the charter,
According to the
that's
charter,
not the case.
it just doesn't address it.
It does, oh, it's silent.
It's silent as to transfers of real property interests. And what I said was that an argument could be made that since the county executive has the power of contracting to the exclusion of the legislature, and since all real properties have to be in the form of a contract under the statute of frauds, that a good argument can be made that the county executive could, the executive branch could hold on to that power themselves. But there is no provision saying in the charter that the county executive has that power. So that's why it's something that if it ever came up, it would likely be litigated, and some judge would either agree that the county executive had it, or would say, as a matter of practice and interpretation of this over time, it was a shared responsibility, even though it's not directly written in the charter, that the law is that it's a shared responsibility.
Thank you.
Thank you, Chairman. Thank you, Mr. Bolden. This is just a great reminder of how important our charter is, because our charter says, and Gary just made a great point there. Our charter says what each role, or each branch of government's role is. And sometimes in certain situations, the charter has been silent. This here, I read this a couple of times already. This is great. And I just encourage all my colleagues to just take this, read it, keep it with you. It is a great tool that you can use to learn more about our role as a legislature, the role of the executive branch, the role of each department in the executive branch, and your oversight as the law department in the executive branch. So I want to compliment you for this. I hate to say it was exciting reading. It's kind of,
I might be concerned about your well-being.
Yeah,
I have a couple exciting things on my desk. If you want.
but it was very important, and because, I mean, one of the greatest things about our government, from the federal government down, is that, our Constitution provides the rules to which the government operates. We have, in our discretion, the ability to change those rules through our charter change. And this just outlines more rules and just to pay attention to them. So I love great thing.
But it, obviously, this is my version of the balance of power, my version of each of these. I think it's very strong. I think that it's beyond reproach. However, you would rely upon your counsel's advice with respect to if she differed with any.
Thank you, Chair.
Any other questions? Well, just, in regards to Barry, is there a precedent set? Because the county executive asked us about selling the gravel. We gave him the approval.
Right.
So he had to ask us because we own, I'm still under that impression that we own all the property. If he wanted something, he can come and ask us. I thought that was the worst thing we've ever done, is just say, yeah, you can sell it, do whatever you want. That's basically what we said. Is that set a precedent something?
Which part of that? I mean, there's several parts. So to unpack it a little bit, is that the fact of transferring real property that's owned by the county to an outside party, it's clear that since the organization of this government is a charter county, that that is a shared goal. The practical way that it would happen is that the executive branch comes and says, we would like to sell some property, we would like to buy some property. So we want your permission to do so, and we wouldn't act without your permission. With respect to the particulars of the sale, right? Whether or not we went through this a little bit with respect to the sale of the property to the town of Montgomery and on what terms they should be done. Again, we would be providing those particulars from our point of view. You made, through the committees, made a lot of changes with respect to what you wanted. And those are all being incorporated into the contract of sale and will be incorporated also into the deed. So as to the terms of it, you also have the ability to weigh in and condition your approval on certain terms.
I don't think that was what happened.
The quarry.
The court, yeah. Court, we gave up all right to him to do whatever he wanted to do.
Well, he couldn't.
Legislative process.
He
Ran through committee.
Well, we asked him if he would come back after we did it. He doesn't have to. Now he can do whatever he wants. He
As
doesn't.
long as they get 1.25.
Yeah.
And money goes to
Right.
It ran through the committee
Fine.
process.
And if the board and the committee did have some comments with respect to, we've incorporated all those. And if in fact the committee, the legislature as a whole wanted additional conditions on it, then the county couldn't have set it out without those
I
conditions.
think we tried to put that condition on when you have a buyer to come back.
And my recollection is the argument that was made against doing that was that they couldn't be in a position to really create a contract to sale because they have to, somebody who said, okay, I'll pay this much for it. And the county said, well, okay, I got to go back to the legislature. And that's, difficult relative to contracts. That was the discussion I.
Well, we always discuss contract rates with some property. But yeah, I don't see that as an issue. I mean, I think if you own the properties, and I guess I'm hearing that we both own the properties.
Well,
The county as a whole.
Yes.
I mean, I was always, for my 24 or 5 years here, I was always under the impression that the legislature owned all the property. And if you wanted to sell something, you could come and ask it, if you gave them the approval, that's fine. Not give up all rights to say, come back to us when you have a proposal, which we did with the board. We did that with the board. He can sell it to whoever he wants without us approval.
That's right. As to the ultimate buyer, that's correct, but that's because this legislature approved that process.
And we did the
That's
same
one.
thing with the town of Montgomery, basically, only we had more requirements and provisions that it had.
But the property has never been owned just by the legislature. That's never been the situation, right? Before the charter county, the property was owned through the government of the Board of Supervisors. When we changed to the charter form of government, some of those powers, all the powers have to either reside in the legislature or the executive or shared in the case of the property. And so there's never been a time in history when the Orange County Legislature has owned property in contradistinction to the executive branch. It's owned by the County of Orange as an entity.
But prior to there being
But
legislative.
I think it's an important distinction. It has to be done the way we've always done it, is that any acceptance of property or getting out of property has to be done by both branches. And if the legislature says, for instance, if the legislature would have said as a whole, not individual members, but the legislature says as a whole, after it comes back, after you sell it, it comes back as to whether or not that buyer is acceptable to us. That poses all sorts of problems, but if you put that condition on it, we would have to comply with that, or we would abandon wanting to sell the property, right? But you have that equal partnership with respect to buying and selling property. I think in circumstances of coming back and having the ability to just, without any standards being set forward, just say, well, I don't like that buyer. That would mean that many buyers may not participate in the process, thinking that some other body, after they're the highest bidder, would just say they don't want us. That combined
That
with,
happened in Capital Board.
Yeah.
Highest
Which
bidder
happened?
highest bidder didn't even, we kicked them right out. The lady said, I forget what the name was, but we'll give you 13 million cash, no questions asked. We didn't go for it. So we can just throw out people too. I mean,
you're very much oversimplifying the two things. No, I'm serious. I mean, it matters. So that there's also the laws that have to be considered. So the law requires us, with respect to the property that we're talking about as to the mine, it requires us to go out and get the highest bidder. That wasn't changed by any other local law or anything else. And so that's what was done. We had to give it to the highest bidder. Now, if you would say, we're going to give it to the highest bidder and pass a local law that says, but we get the ability to throw out the highest bidder. I would certainly counsel the legislature not to have that, because I think that you would affect the marketplace as to who would bid on it with that uncertainty. With respect to Camp LaGuardia, it was governed by different rules. This legislature passed rules specifically with respect to that when they sold it additionally to Mount Corporation. That was something the legislature passed and allowed it to happen in that process. But that wasn't something that the executive branch did on its own at all.
None of us were here, then, except for you.
I really remember. I thought there were four.
No, she wasn't.
No, I wasn't here and I wasn't even supervised.
Okay.
It was my gap.
No sense.
There was a local law that was passed specifically as to that sale, that
Yes.
affect the terms of that sale. That's very different. Well, what I'm trying to do is to say that
No, I understand.
different circumstances necessarily treated different, right? And that was a very different circumstance than the selling of the mine.
Legislators,
Going back to page 7. Yeah, attorney, so, we kind of work independently, but with the county exec as far as a lot of issues go. But this says the executive branches, which we would fall under because it's separated from the county exec and then everybody else is under the executive branch, must follow the advice and counsel of the county executive. So what if there was a conflict between one side versus our own attorney?
But you're to follow the advice of your attorney. Clear about that. And this legislature is not subject to being directed by the county executive as to your legislative functions. So the legislature governs their own legislative functions that they have under the charter. They have the ability to do many things. And when you read through the charter, and it says here are the powers of the legislature, you have quite a number of those powers, right? The biggest of being the power of the purse, right? The power to, the executive branch continually comes to you during the course of a year after the budget is passed. Say, well, we have a new project that we didn't anticipate in the prior budget. So we want you to approve that project and the funding that would go along with it. You obviously have the power to say no. When the executive branch comes in and says, we're either running out of money or it's costing us more money than we thought, we need a supplemental appropriation for something. Again, we come to you asking for permission to go ahead and get those monies. And if you say no, the county executive branch can't do it. So that's the most powerful traditional power of any legislative body in the United States, is that you have the power of the purse to not fund something that the executive branch wants to do. Once you've appropriated monies, now those monies are essentially owned by the executive branch, and they do with it as you've given them permission.
Or you don't have to spend what we give money for. If you want money spent on some project, you can say, I'm not doing it.
Within certain rules, right?
Just
So,
add something to that.
but it's clear that you can't do it willy-nilly. right? So that there are certain rules that money can be under general municipal financing laws that govern what the finance department can do. They can move certain monies from one line to another, but they can't move everything from one line to any other line. Right? So there are rules in place. Those rules we have to follow. So it's not that the county executive is complete carte blanche with respect to any monies to do whatever he wants, regardless of the circumstances under which the executive branch got it. But yes, it's a lot of freedom to move things around within limited areas by the executive branch, which is how the executive branch here, state government, and federal government are all organized in a very similar fashion.
Other questions? Hearing none, thank you.
Thank you very much.
Okay, next up, we have Alan Sorensen, Commissioner of Planning Department, request approval for the Planning Department's DBE Disadvantaged Business Enterprise Program, which is required to be maintained due to Federal Transit Administration regulations. The program is subject to amendment as necessary to ensure compliance with federal law and FTA regulations governing the subject matter of such programs. This request is to officially approve 2023 program updates. Legislative request number 185. Could I get a motion second?
Second.
Fagion and Blank. The floor is yours.
Chairman, thank you. This is a process that we have to go through annually. The legislative request is for the planning department's Disadvantaged Business Enterprise Program, which we're required to maintain due to our Federal Transit Administration funding that we receive. DBE stands for Disadvantaged Business Enterprises, which was brought forth as a component of the Civil Rights Act of 1964, addresses minorities, women, disadvantaged businesses. The DBA program in front of you today is to approve the change of the triennial goal from 1.2% to 1.1%. No other changes took place in the document, which was last approved by the legislature through Legislative Resolution 124 of 2022. Just in terms of background, the goal is calculated by analyzing all DBEs in the tri-state area and those who would be ready, willing, and able to assist us in our contracted services, which include paratransit operation, Middletown area transit services, and our transit consultant. So it's a formulaic goal based on that analysis, and that's what we have brought forth today.
Question?
Just, that's the only update.
Yeah.
So,
Yes.
Seeing no others, I'll call the question. All in favor? Aye.
Aye.
Any opposed? Okay, motion carries. Thank you. And with that, our agenda is clear, so I look for a motion to adjourn.
So moved.
John and Chief.
Executive.